and it provides. Thank you, Senator.
I call Jacinda Ardern.
Chairman, we've just been told by the chair of the Social Services Select Committee, which I have the privilege of being a member of, and heard the submissions and deliberated on the Child Support Amendment Bill, that this bill will make child support, more effective, fairer and more efficient. Well, I wouldn't mind running through that criteria and really testing whether or not that's indeed what this bill has achieved, because unfortunately on this side of the House that is not the impression that we have been left with, having traversed this bill in the Select Committee. And I'd like to start with the general principle, Mr Chair, of why is child support there? We were just told by the chair of the Select Committee that it's not actually about child welfare and well-being. Well, what is it about? What is it about if it's not about the welfare of the child, about making sure a child is well supported whether or not they're with one parent or two, then what is it about? And that was what we strongly argued in the Select Committee, Mr Chair, was surely if that is what this should be about, if it's about income adequacy when parents, for whatever reason, no longer combine their incomes, if it is about income adequacy, surely that's about the welfare of the child. And if it is, why would we not put the paramountcy principle up front in the centre of this legislation? Now, the interesting debate that was had at Select Committee was it was pointed out to us by officials that putting in a principle that said ultimately decisions should be made based on the welfare of the child was actually contrary to the principles of the bill. Now, nothing could be more stark in pointing out that, in our view, we lost our way about what this issue is actually about. Within the complexity of the formulas, the potential feuding of parents, because we know that those parents who use this legislation are generally less satisfied with their child support payments than if they set up a payment system outside of this regime. And we get so caught up in all of that that our fear was that we are losing sight of what it's all about. Now, I understand the legal reasons, the drafting reasons that made the paramountcy principle difficult, but that triggered in my mind that the minister should have started with a first principles review with this legislation rather than adding layers of complexity to an already complex and ineffective formula. So that's the principle of why surely we should be discussing this. The second point that the chair tried to make was that this was about making it fairer. Well, even in Select Committee, we came up with a different threshold for care than what the minister did. So to try and argue that somehow this was an easy thing to establish fairness, I think is quite contrary to the experience we had even deliberating on this bill. The notion, though, that you could claim that it's more efficient, I found quite simply laughable. As the Green Party member has pointed out, $91 million to administer this piece of legislation. That's probably more than what it would cost if we instituted pass on. I'm not entirely sure, but it would be a significant chunk of that anyway. This is going to be a difficult piece of work to administer. The member's also right to point out that IRD systems are going to struggle with it. I would say this probably even seems more tricky than working for families, and that was probably a test for it in the first instance. The fact that IRD, was it 15% increase in workload for case managers trying to navigate this as well, I think also points out the complexity. But ultimately, I think probably what demonstrates better than anything else the fact that this is not going to make our system more efficient, more effective or more fair is that you're yet to probably hear any speaker in this chamber, Mr Chair, elaborate on how the formula is going to work. Now, we heard the Chair say that it would take a modern approach to the care of children in the calculation, whatever that means. Let's be honest, members of the Select Committee, there were whiteboards brought out to try and explain to us how this calculation was undertaken. It is not a simple formula, and this is not about insulting the public, members of the public, Mr Chair. This is about being honest, that when trying to establish a regime that reapportions income across a liable parent and a caring parent, that takes into account thresholds of care, different income levels, it is complex. And we cannot deny that. Surely that's something that we would agree on. So, Mr Speaker, the first point I wish to make is that in Part 1 ultimately should have included the paramountcy principle. Secondly, if we were, Mr Chair, going to take a first principles review of this legislation, we should have looked at pass-on. Now, we are being very honest on this side of the House. No one is denying that pass-on has fiscal implications. But I think most New Zealanders would be shocked to know that childcare payments that are paid from one parent to another parent who may be on government support for their income doesn't go to their child. I think most New Zealanders would be shocked to know that. Now, given that we know the majority of children who are living in poverty are in sole parent households, and that sole parent households from time to time are going to be reliant on government support if their children particularly are at an age where they need full-time care responsibilities, we know that roughly 88,000 from memory, around that mark, our children living in poverty are going to be reliant on sole parent support in that form. So they are the kids who are not getting child support payments, those kids that need it most. Now, all that we asked on this side of the House, acknowledging the fiscal cost, was that the government at least look at it. At least look at it. That's what the Expert Advisory Committee on Solutions to Child Poverty recommended. We at least wanted to take a look and to analyse it collectively as to whether or not we should be doing it. Mr Speaker, Mr Chair, the second big issue that we grappled with as a select committee was indeed the funding formula. I'm going to have a little go, Mr Chair, of sharing how the formula is at least elaborated on in the legislation. If you go to Part 1, Clause 7, it states that the amount of annual child support payable by a liable parent for a qualifying child is determined under Part 2 and is worked out by deducting the liable parent's care cost percentage from their income percentage and then multiplying the result by the appropriate amount set out in the relevant child expenditure table, which identifies, amongst other things, the average annual expenditure on children in New Zealand by reference to average weekly earnings. Did everyone follow? So there are three variations in this formula. First is the proportion of care, and that was something under much debate. Now, when this bill first came in, there was a recommendation that we reduce the threshold so that a parent, to reduce down the amount of child support they paid, had to care for their child at least 40% of the time. That's where it was. This bill became before us and they said 28% of the time. Now, our issue on this side of the House was, in the majority of cases, we are talking about women caring for children. You take 28% of the care, that means that you might be just picking up a weekend. Is that impinging on your ability to then be a full-time earner? Probably not. Is the mother able to be a full-time earner when they're caring the rest of the time 5 days of the week? Much more difficult. So we felt that that threshold needed to be adjusted, and to a certain degree that has been built into the bill. So that's the threshold element. The second part, by deducting the liable parent's care cost percentage from their income percentage. Now, what's the income percentage based on, Mr Chair? I'm talking to the chair of the Select Committee at this point, because the income formula, as the chair I'm sure will remember, is actually based on a core living cost for an adult, which is based on what, Mr Chair? Based on, no, I hear silence on that side of the House, roughly based on the DPB. We use that as to say, well, how much does someone need to earn to survive? Some might question, actually, whether that is enough to earn to survive when you use the DPB as the base for how much an adult might need to survive. And then we reapportion the leftover income. Now, I'm being very crude in my explanation here, but crudely, that is what that formula does. Now, there are lots of variations in it, and there are lots of holes in what you could say whether or not even the base income threshold that we use to establish is sufficient for an adult. But that is what we've run with here. Now, to try and claim that all of that is effective, fairer and more efficient, I still think there's plenty of holes in the argument that was presented from the chair of the Select Committee in that regard. I want to come back to the threshold of care discussion. The 28% versus the 40%. Yeah, we agree, 40% was a high threshold before you start taking into account monetary deductions from your childcare. But we're also making a crude assumption that if you take part-time care of your child, that you're therefore picking up the cost? Are you picking up an equitable cost of doctors' visits? Are you picking up the cost of their school fees? That's not the kind of thing that is roughly calculated on that threshold.
So, Alfred Naro.
I rise to take a call on this reading in the committee stage. Mr. Chair.